Gwewatta was moving without a provision of the law. And this is not the first time I'm using this provision. I've used this provision several times. That is why I know where to find it.
I know you know you have the same power under that law to visit tenancy. You seem to have lost everything, and then you preempt and help the prosecution where they have failed.
Mr.
My Lord,
Mr. Tumwebaze, let us proceed.
Yes, my Lord. Much obliged.
To accuse me of helping the prosecution is unfortunate.
I know I need to do that accusation.
No, you said that I am helping.
If I needed to, I would relay that accusation in chambers, not here. I didn't say
But you said I am helping the prosecution.
My Lord,
they have failed.
Maybe the longer eyes of the court can see what will happen. But my Lord, at this juncture, the court can't say I will revoke section 40.
No,
even
if it's necessary. Yes,
that's what you are ruling saying.
Yes, if necessary. If there is anything there that needs this.
If the prosecution thinks they will need a witness at this stage, they know what to do.
Section 40.
The court cannot again use section 40, my Lord.
But what does section 40 say? I have read it for you.
What you have said.
Does Mr. Katanga agree with what Mr. Tumwebaze is trying to overrule court after the ruling?
No, I am not overruling.
The reason I refer to Mr. Kabega is the senior person in that side. Does he agree to what his junior brother is trying to do?
As a prosecutor, his instructions are contained in the police file which we traversed with his 24 witnesses. And there was no instruction from any witness. If he has instructions now and he claims to have, he must disclose the source of those instructions or who the instructor is. If he does not, then that is speculation and it's evidence from the bar.
Mr. Mwaganya, what do you mean by you have instructions?
I'm most obliged, my Lord, because if it wasn't, my Lord, for your intervention, I was going to kindly ask my learned brother to state the legal basis for his objection. Because as an advocate of this court, in this court, I appear on instructions. And the instructions I'm given, my Lord, I am not under any legal duty to disclose the details of the instructions. I can only disclose the substance of the instructions that I got. My Lord, I'm an advocate of this court. I have a client. I represent the Republic of Uganda. Is the defense insinuating that I cannot be instructed? I am simply putting to Ms. Mole Katanga the instructions that I carry in as far as these facts are concerned. So
my Lord, my learned friend can only have instructions from the DPP. Nobody else. So let him state so. My instructions from the DPP is this, but not a blanket.
My Lord, the instructions I have from the Republic of Uganda, in whose name I appear and prosecute this matter.
Yes, Mr. Mwaganya, ask your question.
I am instructed by the Republic of Uganda that you had the motivation to kill your late husband for property. And I was saying that you had already given this court your position, but if you may, you can still repeat your response to my instructions.
For property, which property? First of all, I did not kill my husband. So which property did you kill him for? And why? You have an agreement in this court as an exhibit. Where I would buy properties and add his name. If I had wanted to, I would not even have put him there.
That you go through what is right.
So
So what, my Lord, I want to know, what is the substantive objection that my learned brothers are raising?
The objection is that
you object to a question. I have not put any question so far. Wait for the question.
you are putting IDs to a witness, and the witness has said those are not my bank statements.
My Lord,
If I would have wanted during your time,
under what law am I prohibited to put a PID to a witness?
Mr. Mwaganya, the witness has stated that
Confirmation of proof versus evidence of connection. Identification is simply are the documents connected to you or to the company in this case. And she has already said so. As to the content or authenticity, she doesn't know. But the fact that the documents belong, the bank statements are in the names of her company, my Lord, that she has confirmed.
For them, from a bank. These are not bankers' entries. These are not bankers' books. You can't just memos from anywhere. But also, my Lord, it's an absolute waste of our court record to tender the exact same memorandum and articles twice. So, with regard to all the documents that could have been obtained from the...
and this is not the first time I'm using this provision. I've used this provision several times. That is why I know where to find it.
my Lord, you know you have the same power under that law to visit tenancy. You seem to have lost everything, and then you preempt and help the prosecution where I have failed.
Mr.
So, but my Lord, as I said,
Mr. Gwewatta, let us proceed.
Yes, my Lord. Much obliged.
The proceedings, first and foremost, neither is Marx, so they are not parties to these proceedings. The documents they are seeking to tender are documents made by Marge and Marx. Secondly, my Lord, the statements, this court already ruled, my Lord, when it came to statements, actually only last week, I think, that the content, because we had objected, we had said that a previous statement had been made, I think that's in respect of the... No, my Lord, when it comes to statements, we had cited a previous statement in writing, I think, and this court said that statements must be, the term statements must be construed narrowly. The statements already written, and I think this was in the case of...
Let's look at
17.
Section 21, when all admissions as to contents of documents are relevant.
Yes, my Lord, they are not relevant.
Unless the party
Proposing to prove them shows that he or she is entitled to give secondary evidence of the content of the document and the rules hereunder contained, unless the genuineness of the document has been placed in question. Section 4 of the Evidence Bankers Book Act, where you're talking about verification, because he's trying to use her to verify, and that's in respect of the signature card. It must be someone who has compared the original with a copy.
The signature card is falls under the
Evidence Bankers Book Act.
that one they can tender for identification.
For identification?
Yes, the signature card.
My Lord,
Yes, my Lord.
if it is disputed.
For the signature card, yes. My Lord, I think we're now together. For the signature card, it's an ID. That one would accept.
We are not together.
She can, I'm saying I'm together with my Lord. I'm never together with you.
Isn't it part of the books that are kept in ordinary course of business?
Yes, it's a banker's book. Yes, my Lord.
Isn't it part of the books?
Account, look at this resolution, look at that resolution. My Lord, the witness did come here with resolutions and said, these are my
And
resolutions.
she said that the resolutions are not the ones she's made. Has she denied the signatures?
She was simply made to read.
She has not denied the signatures.
Which is also a banker's book. Once it has cross-checked.
What about the resolution and the memos?
The resolution and memos are from the company registry.
But don't they enter them into the bank if that is what you're using?
No.
And don't they also use them if you're a company before you can
No.
They look at the memos, they look
No, my Lord, the memorandum and articles, the memorandum and articles are about identification of the company. The resolution first the resolution and secondly the account opening form
Yes.
will constitute the contract.
But now you agree.
Will constitute the contract.
You agree that they are not bankers' books.
They will constitute the contract.
But you agree that they are not bankers.
The resolution, yes, it is not. It can never be.
The resolution, the amendments are not bankers.
For one simple reason, my lord.
The only thing
For one simple reason, my lord.
Let me see what you are trying to explain about.
My lord, for one simple reason. There's a simple reason why they are not a banker's book.
Let us see why the specimen is a banker's book. It's part of the banker's book.
My lord, what I have, that's why I was asking him, he may have given me other things. What I have, my lord, what I have is this document. It's a 2-page document. My lord, a resolution, you don't take a resolution to the bank. You take a registered resolution from URSB.
But it's the resolution.
So what it is, my lord, it's the resolution. It's the URSB.
It's the resolution.
Much obliged.
Isn't it the resolution?
Yes, so it's not a banker's book. It is a
So it is not
company
a banker's
resolution. Yes.
So the resolution is not a banker's book.
Yes.
Yes.
That's what I'm saying, my lord. I'm saying that the resolution is not a banker's book. My objection to the resolution was that it was not certified. It is also not a banker's book. And for that very reason, you can't get it from the bank. You get it from the company registry. What you get from the bank and what is in its books, it is the fact that the resolution is not. My lord, that is my objection.
My lord, Mr. Karwanga is confused.
But my lord, we are ready to agree
Mr. Karwanga is confused.
For me,
My lord, even if
to follow the court,
this
except for 2 things, my lord.
Yes.
We're ready to leave the matter to the court, except for just one thing, if I may, and then we can. My lord, for us, the issue also of identification needs to be addressed seriously. This witness is not competent to identify that statement. The evidence of bankers' books, who can tender them, who can produce them, who can deliver them, is in a law. You do not bring it. Where in that law is this witness authorized to identify them? Maybe if we could be shown a section. With regard to the statements.
Yeah, my lord, 2 things. Mr. Karwanga, yes, and Mr. Karwanga has been also tendering several documents for identification in this trial. Can he cite the law under which he has been making those prayers?
My lord, this court is on record refusing me to tender in documents from the police file, from the person who had the police file, even for purposes of identification.
Okay.
And therefore, my lord, this witness who says I don't know the document.
You were denied the opportunity to tender what document?
My lord, we were denied the opportunity to tender the blood pattern analysis. We were denied the opportunity to identify Bete's statement when Bibiana was here. And she was the one who kept them. She testified, my lord, that she indexed them.
I will need now to go back to the record.
No, no, no.
Verify that. I don't think an opportunity to tender.
To identify.
Identification.
Yes. Mr. Kavega applied and it was not allowed. But my lord, let's deal with the issue before us. Let's deal with the issue before us.
Mr. Karwanga.
Yes. Then the court is saying, for identification purposes, this witness identified it. My lord, that makes the court record false. The witness has said, I don't identify it.
Karwanga, let's end this.
Much obliged. Much obliged. Refused to identify. The court record will be false.